We are live. Going to theoretically let people know who care that I'm going live. They may or may not care. Don't know. Going live. All right. So we have notified people we're going live. So now we are live. So still kind of thinking about doing a fish channel. I'm not really sure how much time and effort I'm willing to put in a fish channel. I might just keep doing stuff over here, regardless of how many views or whatever. But then again, I don't know. Hello, lurking or lurking. So we're going to start today with Wallace. Wallace, for those of you who don't know, sports ball. Holy sports ball. For those of you who don't know, Wallace or Chilli or whoever you want to say did not clarify whether or not he was dismissing against only the individual defendants or not. So the court has ordered that the entire case, the complaint, is dismissed without prejudice as to all defendants. The problem is with trying to dismiss individual defendants is that, obviously you have issue preclusion or claim preclusion. I'm not sure entirely which it would be. I always get the two mixed up. It's a jumble in my head. It's either issue preclusion or claim preclusion. It's part of res judicata or collateral estoppel, one of the two. But the problem is you can get different outcomes that are contradictory. For example, if it was allowed, then you might have the court find that where it's the city defending against the Monell claim, you might have the court find that the officers did violate Chilli's rights or Wallace's rights in this instance, and therefore the Monell claim can proceed against the city. And then at the same time, you might have in the other case where the officers were defending themselves, a different court or even the same court, just in a different case, find that the officers did not violate Chilli or Wallace's rights. And so you can have those two conflicting findings. And so the way our system has evolved to deal with that is if you're dealing with the same nexus of facts, the same causal kind of issue, like in this case, it'd be the same violation of Wallace's rights. What the court does is it requires both of those claims or the claims against everybody to be brought at the same time. That way you don't get conflicting or contradictory holdings or rulings. What new microphone? I don't have a new mic. Oh, you mean in the fish tank video, in the aquarium video? Well, if that is the case, great. I don't have a new microphone for out here. So sometimes I have the ear pod or the earbud in, and that has a different microphone. Otherwise, I've just been using the same cheapy Amazon microphone forever. So this case has been dismissed. We'll see if Wallace refiles it. My guess, and it is just a guess, I don't have anything to support this particular understanding, but my guess is that that Wallace lost faith in Chilli, that Wallace saw how stupid it was and didn't want to have to pay for appeals, etc. And so Wallace basically just lost interest in it, and so Chilli no longer has a client. That's my guess. Because if this was Chilli's case, I thought so for the fish stream. Yeah. Even as loud as it is, it's way louder without that noise canceling. So the noise canceling was doing quite a bit of work. As far as if this was Chilli's case, Chilli would have pushed this to the bitter end. We're going to see that he has filed appeals. There has been answers to his appeals, and I haven't covered them yet, or at least I don't think I've covered them. At least if I have covered them, it's only been kind of perfunctory. So we are going to go over those. So Wallace is dead for now. There's nothing going on in it. My best understanding is that Nevada has a 2-year statute of limitations for personal injury. The statute of limitations for a 1983 action, 42 USC 1983 action, since it doesn't give a statute of limitations in it. The federal courts have adopted the rule that the state in which the 1983 action is filed uses the court will use that state's personal injury statute of limitations to determine the statute of limitations for the 1983 cause of action. Most states are right around a 2-year statute of limitations. Your state may vary. Talk to a local attorney to find out how long you have. Pretty sure that Nevada is a 2-year statute of limitations for personal injury. So Wallace has until sometime around, he filed this in May. So yeah, sometime around May of 2025 to do it. Let's see if he actually alleges a date. Let's see if he actually alleges a date. May 10th. So he has until May 10th of 2025 to refile. So we'll see what he does. As far as Decastro versus the Las Vegas Metropolitan Police Department, there is nothing going on. This is the hold on a second. Let me pull up the Decastro versus LVMPD. There is stuff going on. So this is Decastro versus Las Vegas Metropolitan Police Department. Some things that have gone on is Chilli filed a motion for an extension of time. This is basically to file a motion for reconsideration. It's already been granted, so I'm not going to cover it. He's been allowed to file. He's been allowed an extension of time until November 27th to file a motion to reconsider if he so desires. The briefs are due, since the parties haven't reached a resolution, the briefs are due by the 23rd, November 23rd, or November 27th, excuse me. No, I thought it was November 23rd to, each November 13th. So it looks like Monday, the discovery plans are due. So we will see if Chilli can actually come up with a discovery plan. I don't think Chilli has ever filed a discovery plan. Thank you for taking your pants off. It is the unofficial rule. So I don't think Chilli's ever filed a discovery plan. It will be interesting to see what he files. I'm sure it will be a procedural nightmare, but it'll be interesting to see. Then what I was showing was this. This is the appeal. And the appeal, this is Chilli's versus LVMPD appeal. So we have the actual appeal itself, the appellant's opening brief, and we have the answering brief. So I don't remember going over them, so I'm going to go over them today because I don't remember them, and we'll have to see what they are. I may have done them, and if I have done them, I apologize, but I don't remember it. So oh yeah, I mean there's an art and a science to litigating, and part of that art and science is knowing how to settle, when to settle, what to settle for. In order to be able to do those things, you have to know how strong your case is. In order to be able to understand how strong your case is, you're going to have to be able to understand the law that applies to the facts and the underlying facts themselves. You're going to have a clear picture on what you can and cannot prove. Now, Chilli understands that he can allege a bunch of bullshit, and it's not impossible, but it's hard to get rid of that bullshit just out of the gate. But at the end of the day, Chilli is going to have the problem of trying to prove his bullshit. So he doesn't understand what facts he can prove. He doesn't understand how to apply the law to the facts that he can prove. He doesn't understand the relative merits of his case. He doesn't understand how to settle. He doesn't understand when to settle, and he can't value his case to understand what to settle for. So he's really, it's really kind of stupid to watch him flailing away. He could definitely tie up the court's time. He could definitely tie up opposing counsel's time. He could run up bills for people, but the amount of money that this is costing, for example, the city of Las Vegas is, this is going to be a rounding error as far as their budget is concerned. They don't know and don't care. As far as the federal courts are concerned, again, this is just a rounding error. This is just a whatever. The court's full of people who file useless, unmeritorious bullshit. That would be interesting. Equally useless, but again, interesting. How much do I spend? Chilli is spent on this? Well, it was a $400 filing fee. He paid for service. I think he paid someone to serve. I'm going to guess various defendants, probably upwards of $400 to serve the various defendants. So that's probably $800. And I don't remember how much it is to file an appeal in the Federal Circuit Court of Appeals. How much is that? $505. So probably about $1,500 or so. Probably about $1,500 or so. Oh, we have Surfith in here. Surfith is a fucking idiot. He posts pretty constantly stupid things. He's very, very biased against the police and the state. And the strongest case doesn't matter if it embarrasses the law enforcement caste, except for all the times where the law enforcement officers lose, except for those, right? Right, Surfith, you idiot. Immunity, he says, not understanding it, just throwing the words out there because he's a fucking retard. And he posts constantly. No one even responds to his posts in my comment section, except for me, because he's really just a fucking idiot. And I don't even know why he watches, because he's been subscribed to my channel for probably 5 years, and he has never learned a damn thing. He's never learned a single thing. He thinks that I'm pro-cop. He thinks that I'm, pro-government, etc. He doesn't understand qualified immunity, no matter how many times I've explained it. He doesn't understand anything. He just comes in here, posts inane shit like this, and then walks away. So again, I don't understand why he comes in here. He hasn't learned a fucking thing. But anyway, this is Chilli's opening appeal. So this is just a form that the Ninth Circuit supplies. Not today, but Tom Morrow. Hi, Tom. Smiley face bandit. Where does Chilli get the money for any of this? There can't be that many people giving him money. I would assume that, number one, Chilli makes money from YouTube. Number two, people do give him money. Number three, he does sell stuff on his website. So, and he probably has very low overhead. He probably doesn't have a lot of money going out. He doesn't pay rent or a mortgage. He probably doesn't pay taxes, probably. Hashtag, I don't know that. I'm just guessing. But I mean, if you don't have an address where the IRS can find you, and you don't have any assets that the IRS can take from you, like, then what, right? Well, they've given him the money, Bill. They've given him the money for him to do whatever the hell he wants with. So he had the money. It went into his bank account, so it was his money. And then he took the money out of that bank account to pay for this particular lawsuit. So, and again, he probably gets money from YouTube for ad revenue, AdSense, or whatever. And he does sell stuff online. There are people. I'm gonna go with, there are people who are gonna buy his trifolds and his Fifth Amendment cards because they don't know better, because it's gonna save them if they ever need it, etc. And again, big air quotes around save them if they ever need it, because it's garbage. Like one of the things, I know we're getting a little bit off topic, but one of the things that he likes to say is that you can't get trespassed if you're exercising a First Amendment activity. And we're going to go with for some reason, Justia misspells Adderley. It's Adderley. But one of the things he likes to say is that if you're exercising your First Amendment right, you can't get trespassed. And the point of Adderley versus Florida is the Florida trespass statute was not unconstitutionally applied to people who were there exercising their First Amendment right. And the court goes and lays out that you don't get to exercise your First Amendment right. You don't get to turn any property that you're exercising your First Amendment rights on into a free speech zone. You don't get to do that. And it's in here. Such an argument has its major unarticulated premise at the assumption that people who want to propagandize protest reviews have a constitutional right to do so whenever and however and wherever they please. This is literally Chilli's argument. He's saying that if I'm exercising my First Amendment right, I get to do so whenever, wherever, and however I please. And this is what the court is directly addressing here. This is the U.S. Supreme Court. I mean, it's not like this law has turned into bad law or anything like that. That concept of constitutional law was vigorously and forthrightly rejected in two of the cases petitioner relies on. We reject it again. So the Supreme Court has rejected it in at least 3 cases and probably more. But this is just as of 1966. As of 1966, the Supreme Court had already heard that argument and rejected it 3 times. The United States Constitution does not forbid a state to control the use of its property for its own lawful, non-discriminatory purposes. So his argument that as long as you're exercising your First Amendment right, you can't be trespassed is not based in fact or in law, and we have actual Supreme Court cases on that topic. So, his knowledge of the law is not particularly founded in reality. Trifolds are golden nuggets. Well, they're shit. Hashtag I didn't know that. Well, now you know. Plus, he had fundraised $1,300 for Riot Girl Radio and gave her $1,000 of it. Lol. In Chilli's defense, if you're being given stuff through some of these apps, like YouTube takes a portion, PayPal will take a portion. There's portions taken. So just because $1,300 went in doesn't mean that Chilli actually received $1,300. Is my best understanding. And do you trust Riot Girl? Do you trust her? It always bothers me that people will believe, like, who's that guy who turned on Chilli, who was editing Chilli's videos, delete law or whatever, Colin, I think his name was. But like all of a sudden he turned on Chilli, and then everybody believed every word he had to say about Chilli. And it's like, I don't understand this. Like, you guys maintain a healthy skepticism as long as they're on the opposing side. But as soon as they start saying the things that you want to hear, you just believe it uncritically. It's the same thing with auditors. Like, they understand. They will tell you, like, you engage them in conversation. You'd be like, hey, do cops lie? They'll be like, yeah, they lie all the time. And then you're like, okay, cool. And they go out and they film something, and like the cop comes up and tells them X, and they're like, see, he said X, and they accept X as like the thing, the truth. And I'm like, wait a minute, cops can lie to you. Just because he's saying what you wanted him to say doesn't change the fact that cops can lie to you. Like, where did your skepticism go? It's very unhealthy to have that particular level of understanding. It's very unhealthy. Like, be skeptical about people who have different beliefs and understanding than you, even if they're saying the things that you think that you believe or the things that you want to hear. Maintain your skepticism. Yeah, like so the amount of money the maybe 10 to 15,000, maybe even $20,000 that Wallace chewed up. I mean, it's nothing. And you don't even, like, I don't even know if that 1.7 billion is targeted towards defending lawsuits. They might have a completely different fund for that. Yep. Okay. Fuck, I thought that was my name when this first loaded. All right. Cholito is like sticking your hand into a bowl of Jello. You feel something is there, but it's got no actual substance. Yeah, he completely makes up shit. Remember Fields versus City of Philadelphia and Turner v. Driver were weak cases dismissed by qualified immunity that took away police safety rights. Well, I know Fields versus the City of Philadelphia. That's the one where they found that there is a constitutional right to film as long as in that particular circuit, as long as you're actually adding content to it, as long as you're giving narrative. Turner v. Driver clearly established that you can film the police in public, subject to reasonable time, place, and manner restrictions. Turner v. Driver wasn't a weak case, Sir Fifth. The problem is that before Turner v. Driver, it was not clearly established in the Fifth Circuit that you had a right to film the police in public. Now that right, one of the things that Turner v. Driver did was it established that you have a right to film the police in public, subject to reasonable time, place, and manner restrictions. So now, if the police do it, now they are on notice. They no longer should. I mean, the facts of the case may vary, but in a case at least of identical facts where somebody is on the public sidewalk, filming the police in the performance of their duty, the police can no longer win on a defense of qualified immunity. So again, you're dumb and you're wrong, and you don't understand how qualified immunity works. I saw the vid. He was in his car. I don't know what video we're talking about, but I'm just going to nod my head. Colin Campbell, delete laws clips. Yeah, that was the guy. Project. Yep. That's his new channel name. Although he doesn't understand the Constitution, so I don't even know why he is calling his channel Project Constitution. It'd be helpful if people had a working understanding of what they were going to be talking about, if they're going to be talking about it. I say as I'm making aquarium videos, having very, I know less. I've had aquariums, off and on, but for way more years than I've had a law license, and I know way more about the law than I do about aquariums. There's so many variables that you just don't know, and you can never know with aquariums that you can know if you study it with the law. Chilli FOIA'd LVMPD's legal bills, and he's cost him $48,000 so far. I think that's across both cases. Yeah, sure. I mean, it's not unreasonable for two cases. And that's with Chilli burning up a lot of time with useless, meritless motions that have to be responded to. And it's how much one thing that Chilli hasn't told you is how much it's cost him, because if his relationship with whoever's writing these motions and pleadings, if his relationship with them is similar to his relationship with Colin, then he most likely is paying them for their time. So how much is he investing into it? How much is it costing Chilli? Delete laws, circumcision. Nice. If I claim I'm doing a police protest, does that give me immunity from arrest? No, it does not. It does not. And Chilli can't cite any specific language from a case that makes it so. And if he could, he would, but he can't, so he doesn't. And that other thing that he cites about, if you give the cops permission to search and then you revoke it, then all of a sudden they can't search, is stupid. If the cops ask you for permission to search and you say no out of the gate, then they have to have probable cause to search. They have to have probable cause, unless they're doing a Terry frisk, in which case they need reasonable suspicion. They have to have probable cause or something else, like a search incident to a lawful arrest, or an inventory search. I mean, there are various exceptions to this, but they have to have at a minimum probable cause, right? So if before you give them permission to search, if they wanted to search, they'd have to have probable cause. If you give them permission to search, then they don't need anything because they have your permission. If you revoke your permission, then that's fine. Now they have to have probable cause again. I mean, there are no magic words. Merb, have you used your 5A cop card? I don't have one. Communities suck. And if you're lucky, they swallow. Cherry picking. I like cherries. I believe what you're saying, Merb. Well, don't believe me, because don't believe people. And especially don't believe attorneys. Always trust your attorney. Never trust an attorney who's not your attorney. I'm not sure I trust Chilito's claims about what it cost LV. I also wouldn't believe it, but whatever. At least in California, as long as there is, that's Ninth Circuit. As long as there is litigation going on, attorney fees are protected. So California's law and Ninth Circuit law is that attorney's fees are protected. They're attorney-client communications, and they can give you an idea of what the other side is doing. If the other side starts ramping up spending, you can expect something coming. So I would expect it to be privileged. I would expect the city to not have to turn it over, especially when there's active cases going on. But I don't know Las Vegas's policies on it. They can always give it if they want to. I don't believe they have to under Ninth Circuit precedent, but maybe there's also something in Nevada state law. So I would doubt it, but it's not impossible that he got it. Riot Girl got a trademark lawsuit threat from a management company. My money says that she got a strike from that management company over still using the name. Okay. Well, you shouldn't take other people's intellectual property. That was fundraised using PayPal, etc. He wasn't counting YouTube donations. He said if it went over, I'm going to guess that's 1K, she would get it. And he showed how much he was getting with his phone during the fundraiser. Okay. We're just pointing out he didn't do what he said he was. Well, newsflash, Chilli lies. So great. You've proven what we've already known, that Chilli lies. But I mean, if he got $1,300 and he gave her $1,000, that's, go talk to Dan from Welsh News Network. I mean, at least Chilli showed something, right? But even PayPal takes money. They take a percentage. So I'm sure other forms do too. I mean, that's how PayPal makes money, is they get a percentage, right? Be skeptical of anything you see or hear on the internet. Check other sources. Exactly. And even I'm an attorney, but I'm an attorney in California, and I'm not your attorney. I'm not giving you legal advice. So before you try to implement anything I say, go talk to a local attorney. Things may be entirely different where you're at, and your attorney, if your attorney is going to take your case, then your attorney is going to have their own theory of it and how they're going to prosecute it, etc. I know I work with an attorney who we differ entirely on how we would prosecute cases. And that guy, he can make money off cases that have I remember there's one case, it was a trip and fall case in an apartment complex where there was a crack in the sidewalk that was less than 1 inch tall. It was like about a half inch tall. And California case law is clear that a de minimis crack that's under a certain height, like an inch and change, is a de minimis crack. And by law, a property owner does not have an obligation to you if you trip and fall over a de minimis crack by law. So there's no liability. There's zero liability there. And yet this other attorney, he got like a $40,000 settlement out of it. Out of zero liability. Normally what you have to do is you have to prove not only liability, but damages. He had all these damages. The client was elderly. She fell. She punctured a lung. She was bruised up. I mean, she really got hurt. But there's no liability. And they still paid $40,000. So, I mean, talk to a local attorney. Just because I know exactly what the law is, and I would say that you don't have a right to recovery or whatever, an attorney might still be able to get you a recovery. So, take everything I say with a grain of salt. Double check. Talk to a local attorney. Always talk to a local attorney. Not cock, but my real last name. I would never want to know your real last name, sir and or madam. But if you're into long balls, Dr. Cock McLongerballs is your guy, PhD. Was Turner driving or traveling? Turner v. Driver. Okay. Cops lie, but trust the cops. Who ever said trust the cops? To quote free radio free Tom, I don't know who that is. They use law every day and know more about the law than the judges and lawyers. Well, that guy sounds like a fucking idiot. They don't know more about the law. They know about statutes and they can interpret them, but they don't know about the law. Lawyers and judges will know more about the law than a cop will. Cops will know the statute numbers off the top of their heads. They'll have a good idea of where to go to in the statutes to find what they think is a potential crime, but no. Sorry, Surfith. Once again, Surfith, you prove how fucking stupid you are. So, like, he's stressing a guy named Radio Free Tom to say that cops know more about the law than judges and lawyers. And yet, sometimes cops don't have qualified immunity because lawyers and judges think differently. Ultimately, what the judge says, unless it gets appealed, in which case it'd be what the justice says, ultimately, the judge is the ultimate arbiter of what the law means, what the law says. And the lawyers are there to convince the judge, and the cops answer the questions the lawyers ask. They don't present their own briefings in court. So just wrong on so many levels, Surfith. Once again, you show how completely fucking inept and retarded you are. Thank you, sir. Thank you. Thank you for being the lowest bar that everybody else gets to hurl over, not to be the stupidest person in the room. Are you aware of the writ of certiorari at the USSC right now, asking them to get rid of QI? It also asks them to consider filming the police. Pretty solid argument, interesting case. There have been multiple attempts to get rid of qualified immunity. Unfortunately, it would cause a lot of problems. And I know that qualified immunity is not the best or most optimal system out there, but it's the best that we have. And I mean, you could see, like, let's just assume that we know it did cost the city of Las Vegas money to defend against the Chilli lawsuit and the Wallace lawsuit. And Chilli gets great pleasure about how much money it cost. Let's just assume, arguendo, that we get rid of qualified immunity. That means that every single one of those cases has to go all the way to trial, or at least summary judgment. And that'll add on another anywhere from $10,000 to $100,000, somewhere in that range, about another $10,000 to get summary judgment. Maybe even a little bit more, because you're going to have to deal with all the discovery issues. But easily $100,000 to get all the way to trial. That's not hard to get to $100,000 to take a case all the way to trial. And there are a lot of cases out there that you're not even aware of that get dealt with on qualified immunity. And like if let's say a prisoner sues a warden for a Sixth Amendment deprivation of counsel claim, right? And you see those. Like I've seen them in just browsing around opinions, trying to find various things. You'll see like opinions up on Google Scholar where like a prisoner has sued a warden for a Sixth Amendment deprivation of counsel or ineffective assistance of counsel claim. And that gets dealt with at the qualified immunity stage, because the court's like, I get to actually make a ruling on this, or with prisoners, it's the informa pauperis stage, but it's the same basic thing where the court gets to be like that. There's absolutely no way, even if everything you say is true, there's no way that you could win on this. So, and they get to get rid of it. A lot of qualified immunity claims are gotten rid of on that level. And you can see from how they've dealt with Chilli's claims, except for the excessive force claim, which could in theory be true if they actually did punch his nuts, if they did, could be, but it got rid of all the meritless claims. Like why would we want to have that go forward? As a society, number one, it would cost society a lot of money. We would have to get a lot more courts and a lot more judges to be able to hear all these things and to be able to move them all forward. That's a huge expense. And you're like, oh, well, the cops would have to be more accountable. No, they would be paying more money out for meritless claims. QI really only gets rid of the meritless stuff. I mean, there are exceptions where it gets rid of claims that haven't been dealt with, like Turner v. Driver. Okay, the court's like, there is a right, and now it's clearly decided, clearly established. And sorry, Turner, you lose on this particular claim. He could have gone, but there were other claims he could have proceeded on, but he chose not to continue. And the court's like, unfortunately, you lose, Turner, on this particular claim because it wasn't clearly established, but now it's clearly established. So going forward, I mean, so it's there are a few instances where it doesn't work out, but generally speaking, it does. 9 times out of 100, it's going to go well. Does my aquarium have a yeast infection? Right now, I have one aquarium that has a velvet outbreak. I don't know why. I quarantine all my fish. I don't know why, but it has one. And I'm thinking it might have been something where I didn't sterilize a net or something, moving it between a quarantine tank when I just put fish in there and this aquarium. It could be that. Other than that, I have no idea. And then in my big tank, one of my datinoids has whirling disease. It has some form of disease, which I am assuming is and I haven't added any fish to that aquarium for probably 2 months. And the last fish I added in there, I had quarantined for about 2 weeks and treated, et cetera, blah, blah, blah. So but yeah, I have 2 aquariums that have sick fish in them right now. Let's hope whoever's writing from they're getting fully paid up front. Probably. Hello, Broken Sister, Broken Trust. I don't even know if you are the real one, but hello. Chilito's Las Vegas Clark County trial will be televised on our Nevada judges in early December. Yeah, cool. Is taking inventory for a tow different than searching for drugs by police? An inventory search, they get to search everything. They're taking responsibility for like the car. They get to go through the entirety of it and search it. It doesn't, and they get to search for drugs in the inventory search because they are responsible for everything in that vehicle. They're taking that vehicle, and so they're going to inventory it. So yeah, it's not different. So like after they arrest you, they take your vehicle, they could do an inventory search because they're taking custody of it. Hey, did you see that POS judge panic dropped me from Zoom? I don't watch your channel, bro. So no. I guess I could look at it, but I don't think a judge panicked. You are annoying and obnoxious in the court. You don't know what the fuck you're talking about. You spout nonsense. You're irritating, and you waste time. So I don't think the judge panicked, but I would have to watch it to be sure. Gotta film that. Love the chat reads. We could. This is what I'm assuming. The judge didn't panic, yet no interest in hearing any more of your inane argument about jurisdiction that's never worked and never will. I would hazard that would be why. I don't argue jurisdiction. I ask simple logical questions, see if they have jurisdiction. You don't fucking know what jurisdiction is. You wouldn't know the right answer if they gave it, and your simple logical questions are inane. So yeah. Panic drop, get real. He was succinct and that was it. You're delusional and give Michigan a bad name. But is that true? I have 2 recordings of where it worked for me. Really? Do you? I don't know. Boring. What a snooze fest. Thank you, Bad. I appreciate you. You talked in circles and just late. Yeah, you waste time. Yep. Why don't you find a legitimate reason to have your case dismissed? Oh yeah, you don't have one. The jurisdiction argument. It is nonsense. Texas cops couldn't understand 38.02 about requiring ID of someone detained and not arrested was horrid. Yeah, so some Texas cops don't, but as long as they don't arrest you for failing to ID, then you don't have a problem. Remember, cops can lie to you and they can tell you that you have to ID, even though you don't have an obligation to ID. And they can tell you that 3802 requires you to produce identification, even when it doesn't. They can lie to you. And as long as they don't arrest you for failing to ID on 3802, they haven't done anything wrong, because cops can and do lie to you. I do use circular logic, but that's because the courts can't work that way. Circular logic, I don't know if you understand this, but a circular argument is not a logical argument. A circular argument is something like wheels roll because they're round, things that are round roll, therefore wheels roll because they're round, things that are round roll, therefore, or that. So that's a circular argument. It's not a logical argument, it's circular. You're not actually providing any support to it. So circular arguments are broken. You're dumb and you're wrong. And if you think a circular logic argument works, that just shows how stupid you are. That is Hubert v. Pope. The argument is pretty interesting anyway. Worthy of read? Maybe I'll read it. Yeah, $10K for a retainer for family law. You get into custody situations where people are just willing to spend anything and everything, yeah, you could go through 10K quick. I get tired of honorable courts lying. Like, well, you don't understand what they're saying, dude. They're not lying. You just don't understand it. If QI has gone, that will just force cops to use a collective insurance policy similar to malpractice. No, it won't. Who would insure them? Who would insure them? Literally everybody that the cops arrest can sue them. Even people who they don't arrest can sue them. And it can go all the way to trial. No, I don't think you who is going to insure that? Especially now that I've told you that whether the cop is right or wrong, it could be like $100,000 just to get to trial. And literally everybody the cop arrests can sue them. Who is going to do that? No one is. What would end up happening is that in order to retain cops, in order to keep cops employed, because remember, if cops have to pay out of pocket, that just means you're going to have to pay the cop more. Their salary is going to have to increase so that they can afford to pay for their insurance, their malpractice insurance. That'd be number one. But number two, it's not going to work that way. And so the city would just pick up the defense. And the city already picks up the defense as soon as the city feels like it has merit. So, like, if you remember the attorney in the Decastro case, Decastro versus LVMPD, in Wallace versus LVMPD, the attorney said, "Hey, I don't." Wallace was asking if the attorney would accept service for these cops, and the attorney was like, "I don't actually represent them yet. I have to wait for the city to decide whether or not these cops have merit in their defense before the city is going to pay for me, the attorney, to defend them." But that's the way it's going to work. That's the way it's going to work anyway. And the city's just going to roll it into their budget, which means that you're going to pay more in taxes. I mean, ultimately, at the end of the day, getting rid of qualified immunity is just going to increase taxes. You're going to need more courts. You're going to need more judges or magistrates or both. You're going to need more clerks. You're going to need more taxes by the city to pay the cops an increased salary so that they can afford to pay their malpractice insurance, or for the city itself to essentially act as a malpractice insurance carrier. It is just going to increase taxes, and it's not going to benefit you. Qualified immunity gets rid of the garbage claims. There's a very small subset of the time where qualified immunity will get rid of meritorious claims. It's a very small subset. And we've seen it literally in action in Chilli versus the City of Las Vegas Metropolitan Police Department. It's qualified immunity. It got rid of all but one claim. Well, plus the assault claims that are state-based. People on Reddit talking 50 to 100K for custody from them to support their activist bullshit and be treated like you have a public defender. Okay. There needs to be a better standard for creating a new law for QI, though. The current system seems too exclusionary. Well, I mean, it's not perfect. It's not perfect, and it could be made better, in theory. But we'd have to see. I mean, you got to remember that the system was devised by Supreme Court judges who, in theory, are very well learned, who have a lot of exceptional law clerks working for them, researching the law, who have people filing amicus briefs on either side, who are also very learned. And so they have all this information at their disposal to make these decisions. And the decision they made was, we need qualified immunity, and there you go. And this is how we need to implement it. And I'm just a first-year family law attorney. I don't know about you, Psycho One, but I don't have access to all the information that the court used to come up with its decision. And I don't have the same kind of experience that members of the court have. So, and qualified immunity has been in place for decades, maybe close to a century now. So, I'm not entirely sure that I am qualified to say what better would be, but it is a human institution, so it almost certainly could be made better. Monostat, okay. No, it's an exception to the normal requirement for probable cause. Oh, he put. I totally trust you, Josh. I trust your instincts on what a judge did or didn't do. Yep, there you go. Maybe your sick fish is caused by Chilito dust in the air over in California. I don't know. I don't know. I checked all my parameters, including my dipstick for chili dust, and everything was in good condition. I had a oof. Oh man, that sucks, bro. That sucks. Radio Free Tom Nichols is an American writer, academic specialist on internal affairs, and retired professor at the U.S. Naval War College, staff writes at Atlantic, member of Cop family. Don't care. Don't care. Don't care. How are courts lying? This is a response to Josh. Yes, Josh just doesn't understand. You could play it on my channel. I could, and I might look at it. I normally don't watch you because sovereign citizens irritate the living fuck out of me because you don't understand the law and your arguments. You use words. It's just like a chopped salad full of nonsense. I can't understand what the fuck you're trying to say because I understand the law and I understand the terms, the jargon, the terms of art, and you don't. And so you saying shit. I mean, it's like using medical terminology when not only are you not a doctor, you're not even like a doctor's assistant or a nurse's assistant, where you have no medical training at all. You just saw words and you're throwing them out there, and it doesn't make any fucking sense. All right, hold on a second. We are going to do straw poll. Straw poll. We're going to go to straw poll. Should I play BSBT's video? Question mark. You have, it's a multiple choice. Option 1, yes. Option 2, no. And then we don't want to do that. We don't want one vote for IP address. Okay, create poll. Poll's created, and we're going to paste. That did not. We're going to copy, and we're going to paste. All right, so there is a straw poll. You guys can inform me by the time I get down there. We'll see whether or not you guys want me to vote for it or want me to play it. Foil hats, nice. Excuse me, sir. They are aluminum foil, or if you are in one of the other colonies, an aluminium foil hat. They're not tin, sir and or madam. You didn't panic. That's a good point. If the courts don't have jurisdiction over you, why did you show up? You did show up, so you know. Someone should warn Taylor Court. They screen for weapons. Doesn't help. Truth bomb, dude. You are the only person tooting your own horn. You're the only person in here tooting your horn. Yes, Terry v. Ohio. I would much rather get rid of Terry v. Ohio than qualified immunity. Much rather. Terry v. Ohio improperly, in my opinion, expanded the capability of cops, number one, to detain you, which isn't a thing in the Constitution, and to search you, except just it's over the clothes. You know, it's such a minor imposition. Well, it says judges who never get searched. I mean, you know, be an inner city youth and see how many times a cop's going to grab your nuts in any given week. It's going to be a lot more. So, you know, I think Terry v. Ohio was improperly decided. I think their case law on the border and how you lose the Fourth Amendment at the border, and Martinez, was it Martinez Fuerte? Is that the one where inland border control checkpoints, the 100-mile search zone within 100 miles of the border, where basically your rights are at the lowest, your Fourth Amendment rights are at the lowest. But if you look, like, most of the population in the country lives within 100 miles of the border. The seacoasts are all heavily populated. The biggest cities are within 100 miles of the border. Like, geographically, most of the country is inland, but population-wise, most of the country lives within 100 miles of the coast or of a border. Crazy. What if Texas cops illegally detain someone? You don't detain someone for 3802, you dumb shit. They can detain you for any reasonable amount of time to investigate a crime. Investigating the crime could include trying to identify you. You dumb shit. It's like, you don't understand. As long as they don't arrest you, I chose the fucking words I meant. As long as they don't arrest you for failing to ID, that's fine. They could do that. They could detain you as long as they need to conduct their investigation. And part of what they conduct their investigation is to identify you. Marty, that's a rookie comment. Even Merb will tell you going to court doesn't mean. Yes, it does, you dumb shit. Yes, you does. Yes, it does. The court gets personal jurisdiction over the plaintiff when the plaintiff goes to court and files their. They go to court and they file their complaint. Prosecution, likewise. The court gets jurisdiction over the defendant, personal jurisdiction over the defendant, when the defendant either files their answer, gets served, or shows up at court. Going to court, the court gets personal jurisdiction over you. But even you're so stupid and uneducated that you don't understand the myriad types of jurisdiction there are. So you throw jurisdiction out there, meaning you don't fucking know. But there's personal jurisdiction, there's in rem jurisdiction, there's quasi in rem jurisdiction, there's subject matter jurisdiction, there's territorial jurisdiction, and you don't fucking know. You just thought jurisdiction. The court doesn't mean the court has jurisdiction over you. Well, doesn't. Well, I guess they'll never have quasi in rem jurisdiction over me. Dumb shit. Right? Those are state claims. State claims. But what does everybody want to sue under? They want to sue under 1983. 1983, it doesn't matter if you're in Colorado, Connecticut, New Mexico, or New York City. If you file in federal court a 1983 action, or if you file a 1983 action in state court, which you can do in California, probably can in other states too, then they'll remove it to the federal court. Because once you're in federal court, you use federal qualified immunity. It doesn't matter if the state got rid of it or not. But most of these cases are going to use federal causes of action, because state causes of action, generally speaking, these states are going to limit your recovery. They're going to do other things to ease that burden on the cops, or limit what you could sue them for. DSPT, okay. We also have a video, okay. How's Zoom working out for you? I'd rather see this outrage over civil forfeiture than QI. Civil forfeiture, also completely unfucking reasonable. How can my money have committed a crime if I haven't? Oh, irritating. I mean, you're supposed to be secure in your person's papers in effect, but they could just take your fucking money because your money might have committed a crime. Like, how the fuck does that even work? Okay. If QI is really needed, the legislature should codify it, not the courts. There are statutes that don't allow QI as a defense for USC. Right. So why does the legislature have to again, qualified immunity has been in effect for about 80 or so years, something like that. If it was a problem, the legislator could very easily say, no, court, you got it wrong. And they could write legislation to remove qualified immunity, but they didn't. Well, there you go. I mean, there are cases where and the legislature is aware of it. So if they write it into a statute that says you're not entitled to qualified immunity, that means they're aware of it, which means that they're willing to let it happen for these other things. You're a sovereign citizen. And it's so tired and played out that you think that judges and cops are a sovereign citizen. It's just how ignorant you are. Like, you look like a fucking idiot. You don't even realize it. People laugh at you and you don't realize it. You're that fucking stupid. Like, you have two choices. You have two choices, Josh. Either you're right and 99.999% of the country is wrong, including the most educated people on the subject, or everybody else is right and you, who are completely uneducated on the subject, are wrong. Your choice. I mean, reality exists, Josh, and as much as you want to ignore it, it exists, and you should probably take into account that you're not educated on it, and you're probably wrong. And not every, like, if sovereign citizens tactics worked, I, as a lawyer, would employ them 100%. They don't work. That's the problem. It doesn't work. And a lot of times when sovereign citizens think it works, it's because there was actually like an issue. Like, oh, I've won on jurisdiction. Well, maybe they filed in the wrong court. But you didn't know that. You just tried your stupid sovereign citizen argument, and the judge was like, oh shit, like you didn't put his name on this, or you didn't do this, or whatever. Great point. Too small, your expert opinion. Reynolds rap. Okay, that doesn't mean anything. Fucking the stupidest people in the world can win cases. There was a channel that just did traffic tickets. It was a YouTube channel. All they did was traffic tickets. Traffic court, some YouTube channel. And completely uneducated people just showed up and were like, "You're on, I don't think I should have to pay the ticket." And the judge would be like, "Oh yeah, right here. It's they filled out the ticket wrong. I'm dismissing it." Now, if they go home and they say, "Oh, I won a case," that means I'm a fucking genius. Well, it doesn't. They didn't figure out why. And your arguments don't win cases, Josh. You might have had 2 not guilties. Great. But that doesn't mean that it's your legal argument, your legal acumen that's helped you at all. All right, so we have reached this. So we're going to show the results, and we're going to share this tab instead. So yes is 58%. So we're going to do it. All right, we're going to fucking do it. All right, I'm going to have to put in earbuds. Put in my earbuds, man. All right. And it's broken system, broken trust. All right. I'm going to assume it's this particular video.
Hi, Mr. Lanto.
Hello?
Hi, how are you?
Well, I'd be doing better if it wasn't for the implied threat of violence of the state.
The implied threat of violence of the state. You're a fucking idiot.
Okay. So you're here for a settlement conference today. Was your intent to, I'm sorry?
I'm here under threats and duress and coercion.
No shit, dude. No shit. You had a ticket issued to you or something that says show up to court or else a bench warrant's going to issue.
Okay, that's something you'll have to address with the court.
Oh, they're aware.
Okay. So is your intent today to set this for a trial? You don't want to plead on the case?
Well, my intent would be to have the prosecutor dismiss this.
Okay.
My intent would be to have the prosecutor dismiss this. Oh God, I can't, like, just listening to sovereign citizens drives me the fuck nuts. My intent would be to have the prosecutor dismiss this. That's not in your control. That's not in your control. It's well within the prosecutor's control. And if the prosecutor wanted to dismiss it, he probably wouldn't wait until the court hearing to do it.
Okay, I'm not going to dismiss the charge.
You do have that option though, right?
You do have that option though, right? Ugh.
That it is an option. It's not something I'm going to do.
So you have the option to dismiss this and you're not going to.
Wow. Look at that legal acumen. He figured out that that Josh Josh figured out that the prosecution has the power to drop the case, to dismiss the charges, but is it going to do it after she made it patently clear, like 4 times she had to repeat herself?
That is correct.
So
no, he's not a good man. He's not a good man. Because number one, he spouts legal nonsense, wasting court time, costing people money. People pay taxes to have judges sit in here and listen to his nonsense. And then he goes out and he makes false claims about what he can and can't prove, misleading people, thinking that he has some knowledge. This guy's what? He's a former Marine, former drug user, maybe current drug user. I don't know, with zero legal training, zero legal acumen, but he's a good man because he's out. That's like saying Chili's a good man because he's out there misleading people. That's like saying that any other sovereign citizen out there is a good man because they're misleading people. It's nonsense. They're not good people. Like, it'd be like me going in and trying to educate people on the proper way to treat whirling disease. I don't know. The only thing I know is what I looked up on the internet. I'm not a biologist, a veterinarian. I don't have any special knowledge. It's misleading. You're not a good person by going out on the internet as an authority and spreading lies and misinformation. That's the opposite of what a good person does.
So why would you continue pursuing this?
So your option is to set it for a trial then. Would you like a trial by judge or jury?
Well, you're giving me false options because that's not.
You're giving me false options. You're giving me false options. No, those are your options.
Not the only option. You have the option to dismiss this right now.
Okay, so Mr. Lanto, I'm going to move you into the...
So you're giving me false options because you have the option to dismiss this right now. Well, that's her option, you stupid fucking ignorant asshole. That's her option. She has options that you don't have. You're limited in what your options are. And that's what like, you're ignoring all of this, all the things that are being told to you.
Breakout into the main session with the judge, and you can let him know whether you would like a trial by judge or jury.
And just for the records, just so you know,
Mr. Mitchell, there is no record. I'm going to...
The record would be what the court reporter would be typing out, right? That would be the record. Well, there's the court reporter's record and the court clerk's record, which would be all the filings in the case. Those both would be a record. There's two records, neither of which is this, what he's doing. It's the record is generated in open court or with the filings. Those are the two ways. Lost connection. Okay.
Hi, Ms. Manarino, Mr. Lanto. Today is the date and time set for a settlement conference, giving you, the two of you, the opportunity to discuss the matter. If you guys work out any kind of resolution, that's fine. If not, we're just going to proceed to trial. So, Ms. Manarino, was there any resolution?
So I haven't watched this. You guys know I haven't watched this. So at this point, there's only two acceptable things. There's really only one question. There's only one question. Do you have a settlement worked out? If the answer to that is yes, then you're not going to trial. If the answer to that is no, then you're going to trial. That's it. I can already tell the way this is going. I can already fucking call it right here. Yes, I have a settlement. All right. Then you're not going to trial. No, I don't have a settlement. We're going to trial. That's it. Those are his options.
Resolution today?
No, Your Honor.
All right. And Mr. Lanto, you'll be receiving your notification for the trial date.
well, objection. I just want to make sure.
Objection. What's the basis for your objection? So this is what he's going to try to do is called a speaking objection. Normally, speaking objections are disfavored. Why is it called a speaking objection? Well, an average objection, a normal objection, what the courts don't have a problem with is objection, hearsay. That's a normal objection. A speaking objection is normally done when someone doesn't know what the fuck they're talking about or the legal basis for their objection. So they start saying something like, well, Your Honor, objection, he doesn't have firsthand knowledge of what he's talking about, and so he shouldn't be testifying to something that he heard from someone else. That's what's called a speaking objection. Speaking objections, again, highly disfavored, and almost 100% of the time, it is because the person making the objection doesn't know the legal basis for their objection, or there is no legal basis for their objection. It's going to be one of the two. It's going to be one of the two. Now, in this particular case, I'm going to expect it's going to be a little bit of both. Number one, Josh doesn't understand that he needs a legal basis for his objection or what a legal basis looks like. And number two, there is no fucking legal basis for his objection. This is an improper time for an objection. this is what sovereign citizens do. They fucking waste time and money. The court's already made its ruling. The court's already said, all right, you're going to court. You're going to get the notice in the mail. This hearing's fucking done. There's nothing in front of the judge that needs to be resolved at this point.
Last time I was here, we discussed the issue of jurisdiction. You gave me a charging document, and on that charging document,
He's raising jurisdiction. The only way you could raise jurisdiction is with a moving paper. He could file a motion challenging jurisdiction at this point. He has not filed a motion, therefore it's not in front of the court. Therefore, the court's not going to hear it. You have to give the opposite side an opportunity to look at what you're presenting, plus any affidavits or whatever that are associated with it, any evidence that you're going to attach to it, and give them a chance to respond to the legal merits and factual merits of your objection to jurisdiction. He's done neither of those things. It is not properly before the court. So the court isn't going to do anything other than deny his objection, because it's not even an objection. It's a motion. It would be a motion challenging jurisdiction. It's not even a fucking objection. He's so fucking wrong. It's retarded.
if I had you in federal court on a stand in federal court,
You're not in federal court, and you never get the judge on the stand, you dumb shit. You stupid fucking ignoramus. Look, we've already got another defendant in there. The court's moving right the fuck along.
and I asked you to highlight the word jurisdiction, what would you highlight?
What? The court is not obligated to answer your fucking questions. The court is there to resolve the disputes, not to answer your questions, you dumb shit. The witness in the stand is there to answer your question. Is a judge in the stand? No. Could you call him as a witness? No. Is he under any obligation to answer your question? No. If you're this fucking stupid and you don't understand how jurisdiction works, the appropriate course of action is to hire a fucking attorney and let the attorney explain it to you, because you don't understand it.
So you'll be getting the notice for the hearing, for the trial date in the mail. Have a good day.
There you go. Have a good day.
Okay,
Thank you, Your Honor.
Have a good day. That's it. Look at that face. Look at the face of that fucking judge. Look at that face. That is not the face of a man who is panicked. Jesus Christ. Is there more? Does this dipshit come back on? Is it a bench or a jury trial? Yeah, you'll find out when you get the fucking pleading in the mail or the notice in the mail.
All right, Ms. Manarino, Mr. Lanto. Today's the date and time set for a settlement conference, giving you, the two of you, the opportunity to discuss the matter. If you guys work out any kind of resolution, that's fine. If not, we're just going to proceed to trial. So, Ms. Manarino, was there any resolution today?
No, Your Honor.
All right, and Mr. Lanto, you'll be receiving your notification for the trial date.
well, objection.
Well, if it was important to you to get a jury trial, then maybe you shouldn't have wasted your time talking dumb shit about your objection. Maybe that would have behooved you instead of playing fucking sovereign citizen attorney. And where did you go, Joshy? You fucking maroon. Oh, here we go. We've got another idiot. Qualified immunity is a judicial created fiction to protect government employees from accountability for abuse of their authority, unless it would obviously expose how corrupt the justice system is. Well, I mean, yes, it is a judicial fiction, and it is designed to protect government employees from accountability for discretionary acts. Discretionary acts. That's what it's designed to do. Protect, because if you're a police officer, you have to make split-second decisions about what to do, how to react in the situation, i.e., exercise your discretion. And we don't want police officers paralyzed. That's the rationale for it. We don't want police officers paralyzed, thinking that everything they do is going to end up costing them $100,000 to take it all the way to trial, right? Yeah, where did he go? Where the fuck did he go? He's proud of you, apparently. I did not see him dunk all over that judge. All right. So now that we've resolved that, thank you all for playing along. Now we're going to go to the appellate's informal opening brief. All of this he's filling in. This is Chilli. What are the facts of your case? I'm a member of the press. That's not a fact of your case. In Las Vegas, Nevada, on March 15, 2023, I was recording a police interaction between Las Vegas Metropolitan Police Officer Brandon Bork and a citizen. That is a fact. That is a surprisingly good fact from Chilli. I was in a private parking lot open to the public where I was authorized to be. Authorized is a strong word. You are a, what is that? What would that be? An invitee? You'd be an invitee, I think. Although I made no overt action to interfere with any investigation happening, and I was standing in a place where Bork could easily keep an eye on me for safety reasons, Bork asked me to step back, which I did significantly. Yeah, Chilli is press. When he is recording the police engaged in the performance of their duties, he is press. When he inserts himself into it, he blurs that line and he may stop being press. Well, I hope he's happy there. Drink. The police lawyer reframe. Police make split-second decisions so they can kill innocent citizens at will. See, like, this is how fucking stupid Surfith is. Like, and he thinks he made a point. I was explaining the rationale that the courts have laid out for why qualified immunity exists, and he calls it the police lawyer reframe, which that's the courts. The courts have laid that out. But okay, no, cool. All right. I guess I'm just a police lawyer, apparently, even though I've never represented a police officer, at least in their official capacity as a police officer. And so now they get to just kill innocent citizens at will, except for all the times where they can't, like, see what's that, Derek Chauvin, who killed allegedly. I guess technically he was found guilty of it, so I could say, okay, so he killed George Floyd. Except for when they can't, right, Surfith? We're just going to ignore all the times that they couldn't get away with it, right? Right? And was George Floyd even an innocent citizen? Huh. I mean, so they get away with it except for when they don't. And Surfith is only going to talk about the times they do. Yeah. I think in December. Can you break down poster 7 regarding filming? Why would I break down a poster? A poster is a poster. The actual law is in what, 39 CFR? What is that, like 39 CFR 256 something or the other? 256? 265? Nope, it's not 39 CFR. No, it is. 265.14. Nope. It says Postal Service. It's 39 CFR conduct on post 232.1. 232.1. So this is the actual law. Posters are posters. It's a poster. We don't enforce posters. We enforce laws. A regulation is a law. We don't enforce posters. We we enforce laws. And no, I'm not going to go through it, but the part that you want to read is and the language in the poster is different than the language in the regulation. So you do want to read the regulation. You do want to read the regulation. Here we go. That's the regulation that you want to read. Yep. So, and it's they should always use the Oxford comma. Microphone. Oh, they did use the Oxford comma. Nice. But anyway, so can they? Well, that's a good question, and it would depend on the facts, Dale. Maybe, maybe not. Now the problem is, Dale. We're way off topic here. That's problem number one. So this is going to be the end of my discussion about this. But the problem is, number one, this is very rarely enforced because your local police officer can't enforce this. This is a federal law. I guess technically a local police officer could, but they don't. So what they normally do is they normally rely on trespass, on state law trespass. And whether or not they can do that depends on a lot of things that I'm not going to get into. But typically you're going to use the state's trespass statute, not this. And so you're going to have to figure out, looking at the state trespass law, whether or not the state police officers, i.e. police officers like maybe county sheriffs or whatever, whether they can enforce the state trespassing law based on what you're doing in there. So that's the long and the short of it. Now, where were we? So this is not a fact. These are all things that are his interpretations of the facts. And you're welcome, Dale. Bork demanded that the person he investigated, quote, deserved privacy, end quote, and demanded that it is not black and white, which is why people have attorneys to argue the facts for them. Bork demanded that the person he investigated, quote, deserved privacy, end quote, and demanded that I step back even further, contrary even to the Las Vegas Police Protective Association's training. Well, that's training. That's not a law. Although my rights were clearly established by binding case law to record police and to record in public, Bork tried to enforce his unlawful feelings instead of the law. That is also not a fact. When I asserted my rights as a member of the press and further verbalized my criticism in exercise of my First Amendment right to speech, which is also a clearly established right backed by binding case law, Bork charged me with intent to unnecessarily manhandle me and did unnecessarily manhandle me. That is also not a fact. Bork called for backup, and with the support of his supervisor, I suffered excessive force and battery from Bork and his fellow officers, which has left me with lasting nerve damage. Now, what he is appealing a very specific thing. So I'm going to do this so that I could go back and so he's appealing the preliminary injunction. That's right. He was so he had asked for a preliminary injunction preventing the state of Nevada from going forward with this prosecution. So that's all that's in front of this particular court. This is an appeal of the entire case because he hasn't lost the entire case yet. So that's it. So why he's talking about all these facts that aren't related to the preliminary injunction, I don't know. All right. So Bork called for backup, and with the support of his supervisor, I suffered excessive force and battery from Bork and his fellow officers, which has left me with lasting nerve damage. There are some conclusions in there. There are some statements of fact in there. Overall, this is not a fact, and it's more a legal conclusion than a fact. And it has nothing to do with the preliminary injunction. I was subjected to subsequent unlawful arrest, unlawful search and seizure, and unlawful abuse of process. All of these are conclusions, not facts. Bork and his supervisor on scene even violated their agency's misdemeanor arrest policy to arrest and book me in retaliation for the exercise of my rights and my viewpoints. Again, that's immaterial. They can violate their policy because the policy, your remedy for, or the remedy for violation of a policy is that the police department will punish them. You don't have that right. The policy isn't something that you enforce. It's between the officer and the department. Where a similarly situated individual would not have been arrested by policy, let alone practice. Where a similarly situated individual should not have been arrested by policy, let alone practice. That is what I like to call a sentence fragment. It is not a fact. It is theoretically a conclusion, or a fragment of a conclusion. One of the officers that was on scene has continued to harass me and my dog after the incident. Again, that's a legal conclusion, not a fact. Although there was no probable cause to arrest me, that is a legal conclusion, not a fact. I was arrested and charged with 2 misdemeanor crimes. That is a fact. Although no facts align with the required elements of those crimes, that is a legal conclusion. I've essentially been charged with contempt of cop. That's a legal conclusion, which is obstruction and resisting. Being charged with obstructing and resisting is a fact. At no time did I legitimately, legal conclusion, obstruct any investigation, legal conclusion, nor did I resist any actions in furtherance of my arrest. That is a legal conclusion, which is also not borne out by the video of the arrest. Further, there was no intent. The intent that you have to show in a resisting arrest is that the person intended to do the action. Not that they intended to resist, but they intended to do the action. So if you flail your arm and you hit a cop, that would be battery on the police officer. Now you might say, well, I didn't intend to hit the cop. True. Did you intend to flail your arm? Yes. Oh, shit. Thank you, Psycho One. Did you intend to flail your arm? Yes. Well, that's the intent that they're looking for. Did you mean to do the act? Not did you mean to get the result? And again, all we're looking at is whether or not the court should grant the preliminary injunction or not. The criminal charges were meant, this is a legal conclusion, to simply harass me and chill my civil rights, and are interpreting. Who is interpreting? The charges are interpreting state statutes in a way that violates my civil rights and is contrary to binding case law. All of that is gobbledygook, but okay. We have Mr. Elliott giving out legal advice again. I would be careful of that. Mr. Elliott. I believe we had words about you giving legal advice in my chat. So please stop, because I'm not going to take the time to show you wrong, but I don't trust you giving legal advice. And what you say is probably wrong. Since then, the judge handling the criminal case has stated that I need to, quote, lower my expectations, quote, on what discovery I will get from the state due to it, quote, only being a misdemeanor case, quote, contrary to law and clearly indicative of my inability to get a fair trial. No, what the state has to turn over is all the evidence they're going to use to try to convict you. Number one. Number two is all the evidence that is exculpatory or potentially exculpatory, and that's it. That's all they have to turn over. No, that's good advice. That is not legal advice. That is good advice. I fear that my criticism of police misconduct will end up getting me killed should the malicious prosecution continue in such an illegal manner. That is just speculation at best. That is meaningless garbage. What did you ask the district court to do? For example, did you ask the court to award damage, blah, blah. I asked the court to stay the criminal proceedings, which were brought maliciously against me for the only purpose to chill my rights where the malicious prosecution would have harmed me, and I had a reasonable fear of additional excessive force based on the record. Again, this is all gobbledygook nonsense. He's pretending that he is psychic or something. The court denied the injunction, although it had not been opposed. It doesn't just because it's not opposed doesn't mean the court can't deny it. You're asking the court to do something. If the court's not going to do it, the court can deny it, even if it's unopposed. The reasons the court provided were: one, I did not say what the first criminal hearing was about, which was irrelevant, and I didn't know, and the court could have had an evidentiary hearing. I don't recall the court saying that. I don't recall the court saying that. I don't recall the court saying that. Stupid flies. Problem with having chickens is you have chicken shit. So his quote was the court provided me were: one, I didn't know what the first criminal hearing was about, which was irrelevant and which I didn't know, and the court could have had an evidentiary hearing. So the reason the court provided were: one, that Chilli didn't say what the first criminal hearing was about. All right, so let's see if that's what the court says in here. Decastro seeks to enjoin an ongoing state criminal proceeding addressing whether the obstructed police activity and resisted arrest. Those are important state interests. He has not explained why, and there's nothing to suggest that he cannot raise constitutional challenges to his prosecution in the state case. Decastro contends the timing of the criminal case will chill his rights, but does not say how or why. Finally, he claims he will be subject to excessive force if he is jailed awaiting trial, but he gives no reason to suggest that he will be jailed or why excessive force will be used against him if it is. So I don't see that in here. And then he did a motion for reconsideration. There's a response. Jesus Christ, these flies. Is there an order denying? There's the order denying the motion to reconsider, and nothing there. All right. All right. So I don't know what he's talking about. Good thing he didn't cite to any sources, right? I don't know. I don't know what Chili's motivation is for it. I know what he wrote. I don't know why he wrote it. Number 2, the court incorrectly applied a younger abstention. Well, that's interesting. And 3, the court was ignorant on how a misdemeanor charge with the penalty of jail could result in jail. Okay, hold on a second. Go back to this one again. Oh, here we go. He didn't explain the nature of the first hearing, what he anticipates will happen at that hearing, or how that hearing. So that's a little bit more than what Chili said there. Okay. Finally, he claims he'll be subject to excessive force if he is jailed awaiting trial, but he gives no reason to suggest he will be jailed or why excessive force will be used against him if he is. Okay. Jurisdictions don't move motions to declare him a vexation fix. It would have to be opposing party would have to do a motion, generally speaking. The court is very unlikely to sua sponte do it. The prosecutor has not, in her estimation, she has a good case. So why would she dismiss it? She's not wasting time. She was very straightforward. She was to the point. She was efficient. You were not. You wasted the time. The point of criminal hearings is to have a trial on the merits of a criminal case. That's the prosecutor's job. She's not wasting time. You are. Chili likes to make the facts up as he goes. It's easier to win on the facts that Chili makes up than it is to win on the actual facts. Oh, how many has he bought? How many viewers does he get on a live stream? I've got 205 right now. How many viewers does he get on a live stream? He's bought a lot of viewers or a lot of subscribers. I don't know how many are actual or whatever, but he's bought a lot. I'm not saying that I have more than he does, but and the number of followers really isn't an important number. Good point, Burns. Good point. All right, so back to the informal opening brief. My motion to reconsider with video of the incident was denied because it does not offer sufficient reasons to change my mind, although it raised the errors in law and fact. Well, his alleged errors of law and fact. What legal claims did you raise in the district court or at the BAP? BAP is a bankruptcy. My complaint raised claims of 4th, 14th, and First Amendment civil rights violations, battery, unequal protection, assault, false arrest, imprisonment, invasion of privacy, negligence, and Monell claims for policy practice, supervised liability, and failure to train. My preliminary injunction raised Dombrowski versus Pfister, Supreme Court case. You're not a prisoner. Okay. What issues are you asking the court to review in this case? And what did you think the district court did wrong? Should a court refuse? So he's asking questions now. The court's asking what issues, and he's asking questions. Okay. Should a court refuse an injunction to stay a criminal proceeding brought illegally and in bad faith to shield a person's rights and harm that person in retaliation for exercising their rights? Well, if you had any facts that would make it an illegal criminal proceeding that was brought in bad faith, that was brought to chill a person's rights and brought to harm that person in retaliation for exercising their rights, you'd have a good point. Unfortunately, you haven't shown any facts that support those contentions. Does Younger apply where civil rights are involved and where the person hasn't been charged? Chilli was charged though, so that's a fucking problem. You don't have a hearing date if you haven't been charged. He hasn't been arraigned yet. That's the formal reading of the charges, but he's been charged. Should the court sua sponte assume and infer facts in support of the opposition of a preliminary injunction, even when those facts are contrary to the declaration by the movement and no opposition or proof has been raised by the other party? The problem with preliminary injunctions, we've gone over this in other cases, like the Springer case. The burden is on the moving party. It's not like a 12b6 motion to dismiss or a summary judgment where you infer or you assume that all the facts that could be true that are pled by the non-moving party are true, right? That's not what happens in a preliminary injunction case. The court doesn't have to assume that everything you say is true. You have the burden. And you actually have to state fact. See, Chilli thinks he's saying facts all the time, but he's not saying facts. And so he thinks he said enough facts that he should win, but he didn't state facts. So he didn't win. And even if he had stated all the facts, if they are true facts, then he wouldn't win because it's not what it's not the way he's framing it. Especially, so a nice sentence fragment here, especially where the preliminary injunction would stop irreparable harm to a plaintiff and his civil rights. Well, you haven't proved irreparable harm. When video is offered for proof of likelihood of whining on the merits, does a judge need convincing or only a reasonable jury? Okay. Should a court fail to follow its local rules for an emergency reconsideration and wait 2 months for a ruling, even when all procedures are followed by the movement? Okay. I don't know what local rule he violated. It'd be great if he actually listed the local rule. We'll see if he does. Did you present all issues listed in question 6 to the district court? No. If not, why not? I resolve, except for I did not have the opportunity to raise the delay of the emergency motion or the factual analysis of the video, which should have been determined on whether a reasonable jury could find for the plaintiff, not whether a judge is convinced, which I now raise as trial court error on appeal. I don't even know what that means, but okay. So law supports, all right, Dombrowski, he just lists, okay. All right. Quote, it is well established that the deprivation of constitutional rights unquestionably constitutes irreparable injury. This applies here. What are the facts of Melandris versus Arpaio? Was it a preliminary injunction to stop a criminal proceeding? Let's place your bets. Place your bets. Place your bets. Is Melandris versus Arpaio a case where the court was going to apply a preliminary injunction to prevent a criminal case from moving forward? Oh, it's for detaining an individual based only on knowledge or reasonable belief. So it's a case on detention. Okay. So nope. Detaining, not arrest. Detaining, not charged. Detaining, not criminal prosecution moving forward. So that's, oh, you didn't see that. Let me do this again. Share this tab instead. Go to here. So they seek partial injunctive relief to prevent the defendants from detaining. That means words have meaning. Detention is the standard Terry stop. Detained. So it has nothing to do. It has nothing to do with charging, with criminal prosecution, with it has nothing to do with the Younger detention. In fact, Younger. There is no Younger detention in here. So that's oopsie doodle number 1. So this is inapposite. Does not apply. Sorry. A stay of criminal proceedings will not harm the defendants at all, and plaintiff meets the good cause standard simply by requesting an injunction to maintain the status quo as done here. Q West, this case. All right. Place your bet. You know, Josh, you're done, dude. Shut the fuck up. You're done. You're done. The court case is over. I played the court case. Your analysis of it doesn't mean fuck all to me. I don't care. You're a retard. You're done. So place your bets. Does this case have anything to do? Q West Communications International versus World Quest Networks. Well, I can already tell you, this has nothing to do with the criminal trial because there's no state actor. This is two companies filing a lawsuit against each other. So it doesn't apply. Am LegalNet versus Davis. Well, this could theoretically, place your bets. Anything to do with the preliminary injunction and a younger abstention on a criminal matter. Hold on a second. 673F sub 2D. 673F sub 2D. This is it. An order denying plaintiff's motion for limited expedited discovery, an order denying plaintiff's motion to preserve evidence. What does this have to do with the preliminary injunction? Fuck all. It has fuck all to do with it. So again, that's a strike. So completely inapposite. Regional Rail Reorganization Act cases. This is just a list. I don't know what any of those mean because he hasn't provided anything. The state proceeding provides inadequate protection when the threat to plaintiff's federally protected rights cannot be eliminated by his defense against a single criminal prosecution. This is Younger. He says Younger versus Harris applies here. Younger does apply. That's why they're. I don't care, Josh. You're not going to convince me. There was nothing that cop or that judge did that showed any panic. I'm not going to watch your unlisted video. You can slurp my balls. You're dumb. You're a waste of time. You're a waste of time for the court, and you're a waste of time for me. Please fuck off. So I think what he's saying here is the state is that this is an exception to the Younger abstention doctrine. What is his actual site at 46? At 46. $45. That's 40. What am I? 37, 46. 47. For 46. It's 45. And there's 47. What the fuck am I missing? What the fuck am I missing? That 37 at 46, right? Okay, so that's the quote. So then back here, he says the state proceeding provides inadequate protection when the threat to plaintiff's federally protected rights cannot be eliminated by his defense against a single criminal prosecution. Well, why wouldn't this be, if he wins, then he's no longer, then his act of filming that cop is no longer going to get him in trouble. I don't understand that. Okay. There's no public interest in jailing plaintiff for asserting his civil liberties. Well, the interest is in jailing plaintiff for committing a crime. And defendants have argued none. Right, but they have argued you committed a crime. Public interest, well, the plaintiff or the prosecution has argued that you've committed a crime. The public interest clearly lies in the protection of civil liberties for the plaintiff. Clearly. Padilla versus Immigration and Customs Enforcement Agency. Customs Enforcement. Okay. Let's see if this is a pretrial younger abstention case. Whoops. Younger. So younger isn't mentioned. This is a case where the district court ordered the United States to provide bond hearings to a class of non-citizens who were detained after entering the United States and were found by an asylum officer to have credible fear of prosecution in their native states. The problem with Merb, says Josh, he isn't arguing against me. He's arguing an opposing claim from other legal professionals. No, I was arguing against you, you dumb shit. I'm arguing against you. You're dumb. You don't understand what you're arguing about. And so you don't understand my arguments. Fucking. Plaintiff would clearly win a preliminary injunction on either the sliding scale test. One, a likelihood of success on the merits. You're supposed to be arguing the younger abstention doctrine. Impossibility of irreparable injury, or two, serious questions going to the merits and a balance of hardship strongly favoring the plaintiffs. You have to get past younger still. Where a pro se plaintiff fails to allege elements or make factual allegations, it should be overlooked where the conclusions can be drawn from the facts alleged, not on a preliminary injunction. On a preliminary injunction, it's an extreme thing that should only be awarded in very limited situations. But again, is this a younger abstention case? So Fritzel Clegg sued the Cult Awareness Network over discrimination places of public accommodation. So nothing to do with anything even remotely resembling this case. Do you have other pending cases? No. All right. So that was it on that. But wait, there's more. Then we have the opposition was filed. All right, let's see what we got here. Oh, 33 pages. Ooh. I've answered this before, Josh. You fucking moron. If you ask a lawyer, how do you establish jurisdiction? You've given a partial question, and the lawyer is going to fill in a lot of blanks because you don't know what the fuck you're asking. And so the lawyer's going to be like, well, what kind of jurisdiction is he talking about? And so the lawyer is going to fill in blanks that you don't understand. You dumb shit. Oh. Good night, sweet prince. You're annoying the fuck out of me. You're really stupid. Now it's time for you to flee. In the proceedings below, Decastro moved the district court for a preliminary injunction to stay the ongoing state criminal proceedings under the theory that the criminal proceedings would chill Decastro's constitutional rights. 4 days after Decastro brought the motion, and before LVMPD defendants could file a response, the district court issued an order denying the motion for preliminary injunction, holding that the Younger abstention doctrine requires the district court to abstain from interfering with state criminal court proceedings. Decastro brought an emergency motion for reconsideration, which the LVMPD defendants opposed. The district court denied the motion for reconsideration. Decastro then filed this appeal. The district court properly held that it was required to abstain from interfering with Nevada state court criminal proceedings against Decastro pursuant to Younger, and that Decastro failed to show that this case presents the kind of extraordinary circumstances which could justify federal court intervention in pending state court criminal proceedings. As such, no error or abuse of discretion occurred, and this court should affirm the decision of the district court. Jurisdictional statement. Ninth Court's jurisdiction. Oh, Josh, we're talking about jurisdiction. Oh, the Ninth Court's jurisdiction over this appeal arises from 28 U.S.C. 1292A1 because the order on appeal is one granting, continuing, modifying, refusing, or dissolving injunctions, or refusing to dissolve or modify injunctions, except where a district court, or except where a direct review may be had in the Supreme Court. I must have. It was a panic. I was panicked. I didn't know how to respond, because if he was in front of me, I'd have slapped the shit out of him. You know what, GMK? My singing is amazing. It's the best ever. The District Court of Nevada issued the order, which is now being appealed, on June 12, 2023, and issued its Order 9 reconsideration on August 7th. Yada yada, statement of issues, whether the district court erred in denying Decastro's motion for a preliminary injunction, and whether the district court abused its discretion in denying the emergency motion to reconsider. Statement of the case. Parties, blah, blah, blah. The subject incident, March 15th, 2023 at approximately 4:30 p.m. Officer Bork was conducting a traffic stop of a silver Hyundai Elantra. Ooh, that looks like a fact. Hell yeah, Tracy. Hell yeah. Yeah, I know. Like, he just continues to argue. She's not an attorney, so I don't know why. Yes, and my mom told me I was a very handsome man. And she also really likes your mullet, Juan. She told me that she loves that mullet. She'd love to pull on that mullet. But anyway, that is what a fact looks like. Decastro approached the traffic stop and began recording and talking to the traffic detainee. Another fact. At the same time Decastro approached the traffic stop, Officer Bork was sitting in his LVMPD vehicle. Another fact. Upon noticing Decastro interacting with the subject of the traffic stop, Officer Bork exited his police vehicle, got Decastro's attention, and told him to back up. Facts. Decastro moved 5 feet. That is a fact. Although I would like to know if they fucking measured it. I would love to know if they measured it. How did they come up with 5 feet? That is the record on the appeal. Let's see. Let us see if I could figure out where that is. I don't know where that would be. I don't have the record on appeal. Ooh. Hold on. It was recapped. Hold on. I might have it. Hold on. Supplemental. All right. ECF number 41 at paragraph 22. So we're looking a long way fucking down. We're a long way down. This was originally docket 13. Docket 13 on the original case. And who filed docket 13? That's the amended complaint. All right, so they're taking, so that is from the amended complaint. Those citations are from the amended complaint. So SER 41 is amended complaint. So I guess Chilli measured it, right? Well, the junior attorney, his motions, or what I assume to be his motions, I think were much better than Anderson's. Anderson's I've not liked. Bork again told Decastro to back up from the traffic stop, at which time Decastro began asserting his right to record the interaction. Bork warned Decastro he would detain Decastro for obstructing if he did not move further away from the detainee. All these are from the amended complaint. Decastro insisted he had no obligation to back up because of his status as a member of the press and his right to record police interactions. When Decastro ignored Officer Bork's commands to move back 10 feet, Officer Bork told Decastro he was being detained. Officer Bork told the traffic detainee she was free to go. When Officer Bork attempted to detain Decastro, Decastro refused to comply. Decastro asked for a supervisor and walked with Officer Bork back to Officer Bork's vehicle, at which time Officer Bork informed Decastro he was being arrested for obstruction. Decastro then threatened to sue the officers at the scene. Eventually, Defendant Torrey arrived at the scene. Defendant Torrey authorized Bork's behavior as being within LVMPD policy and said Decastro should be arrested. As noted in Officer Bork's report and affirmed by Sergeant Torrey, the reasons why Decastro was arrested were for engaging with the detained driver, refusing to give an officer a reasonable space to work, and refusing to obey lawful commands after being advised he was being detained. Bork's report further stated that Decastro had admitted to getting in trouble numerous times in the past for the same reasons, and his habitual behavior of obstructing police officers and claiming it was justified because of his right to film the police would continue in the area if he was not cited. Well, that's not cool, but okay. Don't care. Not watching it, Josh. You're a fucking moron. Procedural history. And so Josh, any video that you post, the only way I would give it any credence is what the judge said. Is what the judge said. That's not prior restraint. Prior restraint is telling somebody that they can't publish a video that they've recorded or something like that. This is not prior restraint. But thanks for trying, Six Oaks Farm. Procedural history. On April 17th, Decastro filed his complaint and initiated this matter. Don't really care about the procedural history. Summary of the argument. District Court did not err. I don't believe it did. Decastro requested District Court would enjoin state law criminal proceedings against him on the basis that the proceedings would chill his civil rights. Oh, you know what I want to do? I want to go to your videos, and there's a thing here for comments and mentions, and so I don't see it. So you didn't send me one. You didn't make one, Josh. And if you do make it, I will just post the link. How about that, Josh? How about that? Oh, it's in your community section. Well, then anybody can watch it. So you could fuck off and let everybody else watch it who's interested, and quit wasting my time. And I thought I timed you out. Go away again. But user in timeout. It won't let me do it. Oh well, I guess I can't do it. I tried to put you in timeout. It won't let me. So I guess I can't do it. All right. Boom. Decastro argued to be subject to excessive force. Yada yada. Decastro motion. All right. Argument. Doctrine of the Younger abstention. The quintessential Supreme Court case relating to the abstention doctrine in the context of request for federal injunction to enjoin and/or stay state court criminal proceedings is Younger versus Harris, which generally provides that when a state court criminal proceeding is pending and a party attempts to raise related federal constitutional questions in a federal court, federalism dictates that the constitutional claim should be raised and decided in the state court without interference by the federal court. The issue is that federal courts and state courts are both sovereign. A state court is sovereign. A state is sovereign. Now, there are limited instances where federal law will supersede state law, but a federal court is a sovereign court. You're a 26-year law or 26-year attorney. Go ahead and DM me your bar number there, buddy. Why don't you cite case law showing that them having an understanding about what they would do as prior restraint, about what he does in the past as prior restraint. Go ahead, 6 Oaks Farm. Fucking, I'm a 26-year lawyer. Yeah, right. I believe you. And you're right. I am a first-year family law attorney. So you found me out. You found me out, bro. Film out. And now if I'm such a dumbass and you're a 26-year attorney, right? What the fuck are you doing? What the fuck are you doing in my comment section listening to me break this shit down? Why aren't you breaking it down? Why the fuck aren't you breaking it down? You're coming to a first-year family attorney for insight on how to break down this case? Mr. Expert on prior restraint? You fucking moron. Go choke on a dick. The people I get in my comment section, I swear to Christ, how fucking retarded are you? What are you doing here if you're an attorney, bro? I can understand GMK. He just does BKs. I mean, I understand that. He doesn't do any real law. And if I'm such a shitty attorney, why the fuck is Juan Galt in here? Who's maybe not litigated, but he's worked on cases that are that went to the Supreme Court, several of them. Why the fuck is he here if I'm this bad? You dumb shit. Fuck out of here. All right, so we've done that. Douglas versus the City of Jeanette. Before Younger was decided, the Supreme Court broached the topic of whether a federal injunction in a state court criminal proceedings was proper in Douglas versus City of Jeanette. In Douglas, a group of Jehovah's Witnesses distributed religious literature without a permit in violation of a criminal ordinance in Jeanette, Pennsylvania. They filed a class action lawsuit in federal district court seeking an injunction against said prosecution under the ordinance. The court held that injunctive relief was improper and stated blah, blah, blah. Basically, you got to wait until you're impacted on it. Dombrowski versus Pfizer. This is the one that Chilli cited. In Dombrowski, the Supreme Court held that an injunction against the enforcement of certain state criminal statutes could properly issue under the rare circumstances presented in that case. In Dombrowski, a civil rights organization, the Southern Conference Education Fund, and several of its officers sought a federal court injunction against the enforcement of 2 Louisiana statutes, the subversive activities and communist control law and the communist propaganda control law. The complaint alleged state authorities were threatening prosecution of the plaintiffs under these laws, not within the expectation of securing valid convictions, but in order to harass the SCEF and to dissuade its members from civil rights activities. The appellants in Dombrowski had offered to prove that their offices had been raided and all their files and records seized pursuant to search and arrest warrants that were later summarily vacated by a state judge for lack of probable cause. They also offered to prove that despite the state court order quashing the warrants and suppressing the evidence seized, the prosecutor was continuing to threaten to initiate new prosecutions of appellants under the same statutes, was holding public hearings at which photostatic copies of the illegally seized documents were being used, and was threatening to use other copies of the illegally seized documents to obtain grand jury indictments against the appellants on charges of violating the same statutes. So this is an ongoing thing, like where it doesn't matter if they're getting criminal convictions or not. they're churning, they're using the law against the plaintiffs without any hope of actual getting a criminal conviction. They're just running it up. After quoting the court's prior statement in Douglas concerning the very restricted circumstances under which such an injunction could be justified, the Dombrowski's court concluded the facts alleged in the complaint depicted a situation in which defending the state's criminal prosecution will not assure adequate vindication of constitutional rights. The unique circumstances presented in Dombrowski, as viewed by the court, sufficiently established the kind of irreparable injury above and beyond that associated with the defense of a single prosecution brought in good faith that had always been considered sufficient to justify federal intervention. So right now, all that other stuff that was alleged in Dombrowski, Chilli doesn't have. Chilli has a single prosecution brought against him. Chilli has no way of saying that it was not brought in good faith, and it's most like if Chilli had all these search warrants that had later been quashed, and the district attorney showing copies of Chilli's films and papers and things that he'd taken, like in Dombrowski, then Dombrowski might apply to Chilli's case, but it doesn't. To the extent that the Dombrowski complaint was based on bad faith harassment, it stated a basis for federal court relief that could have been justified under the court's reasoning in Douglas. However, Brennan's opinion for the court offered a substantially broader basis for federal court intervention. The courts recognized that federal interference with the state's good faith administration of its criminal laws is peculiarly inconsistent with our federal framework. It is generally to be assumed that state courts and prosecutors will observe constitutional limitations as expounded by this court, and that the mere possibility of erroneous initial application of constitutional standards will usually not amount to the irreparable injury necessary to justify disruption of ordinary state proceedings. But the allegations in this complaint, the Dombrowski complaint, depict a situation in which defense of the state's criminal prosecution will not assure adequate vindication of constitutional rights. They suggest that a substantial loss or impairment of freedoms of expression will occur if appellants must wait for the state court's disposition and ultimate review in this court of any adverse determination. These allegations, if true, show irreparable injury. The Dombrowski court held the assumption that a defense of a criminal prosecution will generally assure ample vindication of constitutional rights is unfounded, where a statute is challenged on First Amendment overbreadth grounds. The chilling effect on the exercise of First Amendment rights may derive from the fact that of the prosecution unaffected by prospects of its success or failures. The court went on to find portions of the Louisiana statutes unconstitutionally overbroad on their face. Those were the anti-communist portions. The Dombrowski decision was regarded as signaling a newfound receptivity by federal courts to suits seeking injunctions against criminal proceedings based on overbroad state statutes. Is it really rare? Is it really rare? In the wake of Dombrowski, many suits were brought seeking injunctive relief against state court criminal proceedings, though few were successful. One such suit was Younger versus Harris. This is Younger. So on September 20th, John Harris Jr. had been advocating the aims of his political party via the distribution of pamphlets on the steps of the Los Angeles County Courthouse, was indicted in the California State Court and charged with violation of California Criminal Syndicalism Act. Harris brought suit in the federal district court to enjoin the district attorney of Los Angeles County from prosecuting him, alleging the prosecution in the presence of the statute inhibited him in the exercise of his rights of free speech and press as guaranteed by the First and 14th Amendments to the U.S. Constitution. No, he did not. Harris asserted that he would suffer irreparable injury by being deprived of his constitutional rights unless a federal injunction was issued. This sounds exactly like, well, not exactly, but this sounds very analogous to the facts at play, although Harris was, in fact, engaged in solely a First Amendment activity and was not interfering with a police stop. The federal district court held that the statute was void for vagueness and overbroad in violation of the First and 14th Amendments and issued an injunction against the enforcement of the statute. District Attorney Younger appealed the decision, contending that the issuance of the injunction was a violation of the longstanding judicial policy of non-intervention in 28 U.S.C. 28 or 2283. The Supreme Court ultimately ruled the judgment of the District Court enjoining the District Attorney from prosecuting under the statute must be reversed as a violation of the national police forbidding federal courts of the national policy. I think this is a mistype. Must be reversed as a violation of the national policy forbidding federal courts to stay or enjoin pending state court proceedings except under special circumstances. So in a situation that was even more clearly a violation of First Amendment rights, arguably, the Supreme Court said, no, you have to let it play out in the state court. The Younger Court's reasoning in reversing the decision of the district court and limiting the circumstances under which federal courts may intervene and interfere with state court criminal proceedings, the Younger Court explored the history of the abstention doctrine and articulated the profound policy considerations underlying this doctrine. The subsection details the Younger Court's historical and policy-based reasoning, yada yada, yada yada, federalism, yes, yada yada, The Younger Court limited the Dombrowski decision. And it did, which is why it's kind of silly of Chilli to rely on Dombrowski without addressing Younger. But he did. In Younger, the Supreme Court limited and clarified its decision in Dombrowski, refuting the district court's interpretation of the case, which would have substantially broadened the availability of injunctions against state criminal proceedings when a state statute is found to be vague and overbroad on its face in violation of the First Amendment. The Younger Court recognized that there are some statements in the Dombrowski opinion which would seem to support the argument that Dombrowski substantially broadened the availability of injunctions against state court criminal proceedings. However, the Supreme Court clarified that such statements were unnecessary to the decision of the case because the court ultimately found the plaintiffs had alleged a basis for equitable relief under long-established standards, namely bad faith and harassment. In addition, the court did not regard the reasons adduced to support broadening the availability of such injunctions as sufficient to justify such a substantial departure from those established doctrines regarding the availability of injunctive relief in these circumstances. It's undoubtedly true, clearly, as the court stated in Dombrowski, that a criminal prosecution under statute regulating expression usually involves imponderables and contingencies that themselves may inhibit the full exercise of First Amendment freedoms. But this sort of chilling effect, as the court called it, should not by itself justify federal intervention. In the first place, the chilling effect cannot be satisfactorily determined or eliminated. In the first place, the chilling effect cannot be satisfactorily eliminated by federal injunctive relief. In Dombrowski itself, the court stated that the injunction to be issued there should be lifted if the state obtained an acceptable limiting construction from the state courts. The court then made clear that once this was done, prosecutions could then be brought for conduct occurring before the narrowing construction was made, and proper convictions could stand so long as defendants were not deprived of fair warning. The kind of relief granted in Dombrowski thus does not effectively eliminate uncertainty as to the coverage of the state statute and leaves most citizens with virtually the same doubts as before regarding the danger that their conduct might eventually be subjected to criminal sanctions. Is it? I don't know. I think it's unnecessarily long, but what do I know? I kind of get the idea that a lot of lawyers, you get page limits in appeals and responses to appeals, reply briefs, and lawyers seem to want to use all of those pages. I don't particularly understand it. I'm sure the Court of Appeals understands the Younger abstention doctrine. Honestly, I'm sure it does. Chilli doesn't, but I'm sure the court does. So there are exceptions, and the two exceptions to the Younger abstention doctrine are bad faith prosecution and harassment, and a flagrantly and patently. Yeah, me too. Well, I was bored too. So if it's patently unconstitutional law, flagrantly and patently unconstitutional law, which I don't believe that what he was arrested for was obstruction, and I don't believe that is patently and flagrantly unconstitutional, and I don't think it's a bad faith prosecution or harassment. So The bad faith exception predates Younger and essentially asks whether the party seeking injunctive relief has demonstrated the state law criminal charges against him were brought in bad faith. And notice it's whether the party seeking the injunctive relief has demonstrated the state law charges against him were brought in bad faith and for the purposes of harassment. And unfortunately, Chilli hasn't shown shit. Well, fortunately, unfortunately, I guess it would depend on which way you're looking at it. Unfortunately for Chilli, he hasn't shown shit. The Supreme Court understood Nebraska to be a case presenting a situation of the impropriety of state officials invoking the statute in bad faith to impose continuing harassment in order to discourage appellant's activities. In contrast, the Cameron Court and the Younger Court found no basis in the appellate record of harassment, intimidation, or oppression, and accordingly found that no injunction should issue. So that's really what we're looking at. It's super rare. The patently unconstitutional law exception. The Supreme Court described it as follows. It is, of course, conceivable that a statute might be flagrantly and patently violative of express constitutional prohibitions in every clause, sentence, and paragraph, and in whatever manner and against whomever an effort might be made to apply it. This exception is mostly a hypothetical, as it is unlikely the Supreme Court will ever review a statute which is flagrantly and patently violative of express constitutional prohibitions in every clause, sentence, and paragraph, and in whatever manner and against whomever an effort might be made to apply it. In the many years since the Younger abstention doctrine, the Supreme Court has not found there to exist a patently unconstitutional law sufficient to justify a federal court injunction against a state criminal proceeding. So, very rare. The district court properly held that Younger controls here and no injunction should issue. In the preliminary injunction motion, he noted that he has been arrested and cited for 1, false statement, 2, or obstruct police officer, and resisting public officer. Those misdemeanor charges constitute state law criminal proceedings, which Decastro seeks to say via federal injunction. Decastro generally argued that because he was merely exercising his free speech and recording the police and challenging the requests of the police officers, and because the charges have not yet been brought against him, the threat of criminal prosecution and imprisonment would have a chilling effect on his constitutional rights. Decastro contends that as a result, the proper course of action would be for the district court to stay the state court criminal proceedings against him and to allow him to proceed with his 1983 claims in federal court. In support of his preliminary injunction motion, Decastro made 4 one-sentence legal arguments. Decastro, he would have to buy me dinner first, and there would have to be some proposition of him sucking it before I would show him my cock. Decastro first argued that his exercising his clearly established right to free speech is not obstructing or resisting. Secondly, he contended that he had the clearly established First Amendment right to record police. Third, Decastro asserted he had the right not to be harassed based on his viral videos criticizing the police. Fourth, and finally, Decastro contended that the federal district court has the authority to stay in action that chills Decastro's civil rights, especially as charges have not yet been brought. As this court can see, the first 2 arguments raised by Decastro in support of his preliminary injunction motion are arguments about the merits of his federal claims and the merits of state law criminal proceedings against him and have little to no relevancy as to his request for injunctive relief pursuant to a Younger analysis. Decastro's third argument appears to be an assertion of bad faith prosecution based on his purportedly viral videos criticizing the police. Decastro's fourth and final argument, relying on Nebraska, relates to the authority of federal courts to enjoin and or stay state criminal proceedings. Taken together, however, his arguments do not demonstrate that this case falls within the narrow set of extraordinary cases in which it is appropriate for federal courts to interfere with state court criminal proceedings. Merb damage. Probably not. I don't think he has enough self-awareness, my estimation, to really take umbrage with me. He's so self-assured that he knows the law and everything about it that I don't think he really cares what I have to say, to be honest with you. Unless he thinks that I'll support his position. But I think he gave up on that. He hasn't texted me or emailed me in a long time or called me. In the motion for reconsideration, Decastro contends the district court made a clear error in denying his preliminary injunction because the district court did not address his argument that the charges against him had not yet been brought and thus were not pending. However, Decastro acknowledged in the preliminary injunction motion that he was arrested and cited for the 2 misdemeanor charges and asked the court to say what he believed to be a state law criminal arraignment hearing. Thus, Decastro's contention that the criminal charges against him were not pending at the time he sought federal injunction is factually inaccurate. Moreover, what he described as he described there being charges against him. I do get on people's nerves a lot. It's my superpower. Are you questioning a 26-year practicing lawyer? Dude, like, I work for and with, in one of the practices I work for, a guy who's been practicing law for more than 50 years. And I shit all over his legal theories all the time. So I don't care how long you've been practicing. I've been practicing long enough to know what the fuck I'm talking about. And if you think I'm not, make your own fucking videos. And don't come into my fucking stream trying to talk to me about how you know so fucking much with a name like Thousand Oaks Farm or whatever. Fuck off out of here. Moreover, Decastro failed to present the district court with any evidence that charges against him were not yet pending, instead offering only self-serving contentions that the charges have not been brought and therefore criminal proceedings were not pending. Lastly, as explored below, whether or not criminal charges against Decastro were pending is not pertinent to the Younger analysis, where, as here, Decastro is not challenging the criminal statutes as constitutionally impermissible. I know, I'm sure you are. I mean, everybody in here is a fucking 20-year law scholar and 26-year attorney, right? So, subsection A. Criminal charges against Decastro were not brought in bad faith or to harass Decastro. Although Decastro contends these state law criminal proceedings against him are intended to harass him, Decastro is not established that is being prosecuted for obstruction of a public officer and resisting a public officer is a bad faith prosecution or intended to harass Decastro. To the contrary, the misdemeanor charges against Decastro have clearly been brought in good faith based upon Decastro's decision to interfere with an active traffic stop and his subsequent choice not to follow the commands of Officer Bork to move away from the traffic stop. The state of Nevada has an important interest in enforcing its criminal laws free from federal interference. Oh, shit. We've got Justice Stevens in the house. What? In the butt. What? In the butt. You want to put in my butt? In my butt? The state of Nevada has an important interest in enforcing its criminal laws free from federal interference, and the state criminal proceedings provide a fair and sufficient opportunity for vindication of Decastro's federal constitutional rights. 6-year YouTube law understudy. God damn, son. 69. You've been studying YouTube law longer than YouTube has existed. You, sir, and or madam, are a magic person. If indeed you are a person. Maybe you're a bot. No person is immune from prosecution in good faith for his alleged criminal acts. Where the threat prosecution is by state officers for alleged violations of a state law, the state courts are the final arbiters of its meaning and application, subject only to review by this court on federal grounds appropriately asserted. The bad faith and harassment exception to the doctrine of Younger abstention only applies in exceedingly rare circumstances, such as those in Dabrowski. Defendants in state criminal proceedings routinely allege that state criminal proceedings violate their constitutional rights, including fundamental rights, which make this a regular occurrence, not an extraordinary occurrence. Or not an extraordinary circumstance. Here, Decastro has failed to prove or even allege facts sufficient to demonstrate that state law criminal charges against him have been brought in bad faith or as a method of harassing Decastro for exercising his First Amendment right to record police interactions. That is an accurate summary. With regard to Decastro's argument that Dabrowski permits an injunction because state law prosecution threatens to chill his civil rights, the argument misstates relevant law insofar as that portion of Dabrowski was abrogated by Younger. Yup. Furthermore, Decastro has failed to explain or demonstrate what chilling effect on his civil rights that the prosecution could have, and his situation is no different in substance from that of any criminal defendant facing the potential loss of a constitutional right, including the most fundamental right to liberty in the pending criminal prosecution. Moreover, the existence of a chilling effect, even in the area of First Amendment rights, has never been considered a sufficient basis in and of itself for prohibiting state action. See Younger. Where a statute does not directly abridge free speech, but while regulating a subject within the state's power, tends to have the incidental effect of inhibiting First Amendment rights, it is well settled that the statute can be upheld if the effect on speech is minor in relation to the need for control of the conduct and the lack of alternative means for doing so. The instant case is clearly one in which the criminal statutes being enforced against Decastro do not directly abridge free speech and arguably do not even have the incidental effect of inhibiting First Amendment rights. As such, the Dabrowski Court's discussion of chilling effect on constitutional rights is inapplicable in this case, where the statutes being enforced are unrelated to a citizen's right to free speech and free expression. Accordingly, Decastro's bare allegation of a chilling effect on his civil rights does not come close to a legitimate justification for injunctive relief to say the state court criminal proceeding. That's what happens. Well, I must be a noob. Low B. That's one thing that auditors tend to get wrong all the time. Just because you are engaging in a First Amendment protected activity does not mean that you get to do other criminal actions. Like, you can't trespass just because you're filming. You can't resist arrest just because you are criticizing the police. You can't commit a crime and get away with it just because you are also engaged in a constitutional activity. I don't give a fuck. I don't give a fuck. Oh, you never want to fight with your wife. All right, the next section. With respect to Decastro's argument that injunction is permissible because charges against him have not yet been brought, this argument is factually incorrect. In the preliminary injunction motion, Decastro noted he was cited for 1, false statement or false statement to or obstruct police officer, NRS 197.190, and 2, resisting public officer, NRS 189.280.3. Decastro's motion for preliminary injunction requested district court stay a hearing in the state criminal proceeding scheduled for June 13th, 2023. As such, Decastro was and is manifestly incorrect in his contention that criminal charges against him are not pending. Furthermore, even if Decastro was correct that the Nevada state criminal charges against him were not yet pending, Decastro misinterprets case law he relies upon for the proposition the lack of pending charges would justify injunctive relief here. In Doran versus Salem Inn, which Decastro relies on, the plaintiffs against whom no criminal charge proceedings were pending were challenging the constitutionality of the subject town ordinance prohibiting topless dancing. Similarly, other cases Decastro relies on for this argument also deal with plaintiffs challenging the constitutionality of state criminal statutes. That's Woolley versus Maynard, where plaintiffs brought suit for declaratory and injunctive relief against enforcement of New Hampshire statute making it a crime to obscure words live free or die. Hicks versus Miranda, where the theater owner brought action against local officials for declaratory relief as the constitutionality of California obscenity statute and for injunctive relief with respect to seizure of certain films. Huffman versus Pursue Ltd, lessee of a theater which had been ordered closed under Ohio nuisance statute because obscene films had been shown at the theater, brought action for declaratory and injunctive relief challenging the statute. And Hawaii Housing Authority versus Midkiff, trustee of landholding estates, sought judgment declaring Hawaii Land Reform Act of 1967 unconstitutional. In this case, Decastro is not challenging the constitutionality of NRS 187.190 or NRS 199.280.3, but instead has brought a civil action for deprivation for rights under 42 U.S.C. 1983. That's correct. Yep. As the district court correctly recognized, Decastro's bare allegation that criminal charges were not yet pending against him is wholly insufficient to make it the incredibly difficult showing that a federal injunction against Nevada state court criminal proceedings would be appropriate in this case. Moreover, even if his assertion that criminal charges were not pending was correct, it is an irrelevant point where, as here, Decastro is not challenging the constitutionality of the criminal statutes under which he's being charged. And that's like, this kind of goes to Josh, like, Chilli finds language that he doesn't understand, and he tries to use it to support his position, but he doesn't understand the case, and he doesn't understand the law. He doesn't understand why it would or would not apply to his particular fact pattern. Just like Josh, broken sister, broken trust, doesn't understand what the fuck he's arguing, or what the context or the meaning of the words. Decastro's new arguments in the motion for reconsideration should not be given consideration. An FRCP 59E motion for reconsideration may not present evidence or raise legal arguments that could have been presented at the time of the challenge decision. That's correct. We should just accept that as correct. This court properly denied Decastro's motion for reconsideration of his motion. Okay. I'm going to assume that's correct. All right. So that's it. Thank you all for watching. You had 21 days to file an optional reply. What's he going to do? What's he going to do? Like, there's no reply he can make. He can't. He did not have a sufficient factual or legal basis. Making a reply is he can't add new facts. It's an appeal. He can't argue new case law. He's already had a shot. All he could do is try to rebut what they said, but he can't. Like the problem is that it's a loser. Like there's no way to make a loser a not loser. It's not arguable. It's just a loser. I make claims. Or no, I ask questions, not claims. I'm just asking questions. You're a fucking idiot, dude. You are. I can't express this any clearer than you're a fucking idiot. You don't know what you're doing, and not making claims but only asking questions doesn't change it. You're asking the wrong questions. You don't understand the questions you're asking. Not only are they wrong, but you don't understand what you're asking, and you don't understand the answers. So you're just wasting everybody's time. You don't understand the question that you're asking. You don't understand the answers that you're given. You're just wasting time. You too. Jacking off all day. Nice Papa Sanser. All right. Thanks for watching. Have a great day.